Hello there and welcome. Today, we're going to look at the very foundations of the American legal system, but I want you to think about it a bit differently, not as a collection of dry, dusty rules, but as a piece of architecture. We're going to analyze its design, pinpoint the structural stresses, and see how its blueprint is, well, quite radically different from many of its European cousins. Now, this rather punchy quote gets right to the heart of the matter. It comes from a way of thinking called American legal realism. The idea is that the law isn't just what's written down, but what judges actually do. So if the law is merely a prophecy, as they say, of what a court might decide, then it's inherently uncertain. And this isn't some flaw in the system, it's a fundamental feature, one that sets the stage for some really profound problems. So here's our roadmap. First, we'll look at the two basic blueprints, structured code versus the, well, chaos of case law. Then we'll talk about the judges themselves. We'll uncover a secretive process called the shadow docket, then analyze the organized groups trying to influence the courts, see how all of this affects your vote, and finally, look at a big proposal for reform, ending the so-called eternity clock. Right then, let's crack on. At the heart of any legal system is where its authority comes from. Is it a carefully built, written code, or is it an ever-shifting, evolving body of past decisions? This is the fundamental architectural divide we need to understand. You see, it really is a tale of two philosophies. On one side, you've got the civil law tradition, which has its roots in Roman law. Here, the law is written down, it's systematic, it's passed by a parliament, and it's designed to be predictable. But on the other side, you have the US system of case law. It's more like a vast, unpredictable sea of past judicial rulings. The law isn't so much written as it is interpreted, case by individual case. And choosing that second path has some massive consequences. The sources we've looked at highlight 6 key issues. First, predictability is terribly low. Past decisions or precedents can be overturned in a heartbeat. Getting justice can become elitist. You need incredibly expensive lawyers just to navigate the maze. Judges start acting less like referees and more like lawmakers themselves. The whole system can swing wildly based on who's on the court. And ultimately, these judge-made laws lack the clear democratic stamp of approval you get from a parliament. Which brings us neatly from the blueprint to the people working with it, the judges. You see, their role is understood in completely different ways. Are they neutral public servants applying a written code, or are they powerful sovereigns who get to shape that code themselves? And this table just lays the contrast bare. In the German model, for instance, judges are career professionals. They climb the ladder based on merit. To get to the top court, you need a 2/3 majority in parliament, which basically forces the parties to agree on neutral consensus candidates. Their job is simply to apply the law as written. The US model, well, it's the polar opposite. Judges are political appointees, often chosen for their ideology. Getting confirmed is a brutal partisan battle, and their role often bleeds into making policy. So you can think of the German system as having a built-in firewall. That 2/3 majority isn't just some arbitrary number. It's a structural defense mechanism. It's specifically designed to filter out the more extreme candidates and to make sure the judiciary stays above the political fray. Right. Now, inside this American system, there are certain features that seem almost custom-built to exploit these structural weaknesses. And one of the most important and frankly least understood is the Supreme Court's so-called shadow docket. So how on earth does it work? Well, it's a pretty straightforward and some would say disturbing 4-step process. A lower court blocks a government action. The government then files an emergency appeal straight to the Supreme Court. The court then pushes out a rapid ruling, often without any signature, with no public hearing, and, this is the crucial bit, no written explanation. And just like that, a major national policy can be put into effect, having completely sidestepped the normal, transparent legal process. And believe me, this isn't just some dusty theoretical problem. The Trump administration used this route like never before, and the Supreme Court granted its requests in a staggering 80% of cases. It really shows how the shadow docket can morph from an emergency release valve into a powerful political tool for whoever is in power. Now, these structural weaknesses don't just sit there on their own. There are highly organized, long-term campaigns designed specifically to take advantage of them. So let's have a look at the architects who are trying to redesign the judiciary from the inside. The sources we've analyzed point to a very clear, methodical strategy from networks like the Federalist Society. You can think of it as a production line. First, create a farm system to nurture and vet lawyers and judges who share your worldview. Then you essentially take over the White House's job of picking judges, making sure only your pre-approved, ideologically pure candidates get through. The endgame? to install these loyalists in powerful, lifetime jobs where they can provide the legal reasoning to expand the power of the executive. What this creates is a really powerful, symbiotic relationship. The judiciary stops being a check on power and instead becomes what one source calls a judicial shield. It provides the legal cover for an executive sword, that is, for very ambitious and radical policy programs like Project 2025, which is a detailed plan to fundamentally reshape the U.S. government. And the consequences of all this ripple outwards, threatening the most fundamental part of a democracy, the vote itself. It turns out the very design of the U.S. electoral system has flaws so deep that they can make a citizen's vote effectively, well, vanish. At the core of all this is the Electoral College. It fundamentally distorts the simple democratic principle of one person, one vote. What this chart shows is that because of the way electoral votes are handed out, a single vote for president in a low-population state like Wyoming carries vastly more mathematical weight than a vote in a huge state like California. It's just not an equal system. And that's really just the start of it. It means the person who gets the most votes nationwide can still lose the election. Winner-take-all rules mean millions of votes in many states are effectively worthless. It forces campaigns to ignore most of the country and focus on a few swing states. And perhaps most worrying of all, its complexity creates all these little legal loopholes and vulnerabilities that could be exploited to overturn the will of the people. Okay, so we've identified some pretty deep structural cracks in the foundation. In our final section, let's look at one of the major proposals for renovation: getting rid of the eternity trap of lifetime judicial appointments. The scale of this problem is pretty shocking when you see the numbers. Historically, a Supreme Court justice served for about 15 years. Today, that average has exploded to 26 years. This creates what critics call a gerontocracy, rule by the old, where a tiny group of judges can shape the law for an entire generation, long after the president who chose them is gone. The most popular proposed fix for this is a straightforward 18-year term limit. The logic is simple. It would create regular, predictable turnover on the court. It means every president would get to make a specific number of appointments, which would end the current high-stakes political lottery, where one president might get 3 picks and the next gets none at all. The upsides, proponents argue, are pretty clear. It would end the eternity trap. It would take the politics out of retirements so judges don't just hang on for a friendly president. It would make appointments a normal, regular part of government, not a massive political firestorm every few years. And most importantly, it would help make sure the court's makeup slowly but surely reflects the long-term will of the voters. And all of this really leads us to the one big question that hangs over this entire analysis. The U.S. constitutional design is a product of the 18th century. It's now facing the brutal, hyper-partisan pressures of the 21st. The question is, can an architecture designed for one era truly withstand the political storms of another? So, let's have a quick recap. We've seen how the very nature of U.S. case law creates instability and risk. We've looked at how political appointments and secretive tools like the shadow docket have dragged the courts into politics. We've identified the deep democratic flaws in the Electoral College and lifetime judicial terms. And we've seen that other countries, like Germany, offer a completely different model, while proposed reforms in the U.S. are all about trying to restore some democratic accountability. The architecture of any democracy is never truly finished. It requires constant upkeep. Understanding its original blueprint, with all its strengths and all its weaknesses, is always the essential first step. Thank you very much for joining me. You can find a full list of all the sources we used for this explainer on your screen now.